make your appearances?
Good morning, Your Honor. My name is Megan Morrow. I represent Felix Thomas.
Good morning, Your Honor. My name is Kylie Myers. I represent Felix Thomas.
Good morning, Your Honor. My name is dracar and I represent Felix Thomas.
Good morning, Your Honor. My name is Brittany White. My name is karlighe. We represent William, the defendant opponent.
Okay, I've read your motion and the opposition to the motion. Let me go ahead, let me hear from mover, from plaintiff first.
We file this motion for summary judgment since there are genuine issues of material fact that remain in this case. Therefore, we request that Your Honor grant our motion for summary judgment. We would like to enter the affidavit of Felix Thomas into evidence, where it states that Mr. Williams pled guilty of his improper turn at the crime.
Okay, so are you offering that into evidence?
Yes.
Go ahead and do so formally.
I would like to enter the affidavit of
Your offer filing and introducing into evidence.
introducing the affidavit of Felix Thomas into evidence.
Any objection, counsel, to the introduction of that affidavit into evidence?
Yes. Hearsay?
Let me hear your argument on why. Are you moving to strike this?
Yes, ma'am, because it's hearsay. Our opponent says he did not say that.
Okay, well, that's not necessarily hearsay if he says something opposite. Hearsay, as you're aware, counsel, is when someone is stating that someone else said something to them. So does this have any hearsay?
No, but it does have reasons that conflict with what Danny Williams has said, proving other things opposite from what happened.
Okay, can you respond to that?
The affidavit comes from a reliable source, being that Felix Thomas has been in law enforcement for 15 years. So even if it is considered hearsay, it is coming from a very reliable source.
Is that hearsay?
I don't believe so.
No, I don't think that's hearsay, right? Go
I
ahead.
do have one thing to say, that Danny Williams has never sworn in to saying that he takes full responsibility, which was what was sworn into that affidavit.
Okay, let me, and I want to, this is the affidavit of Danny Williams you're talking about, or Felix Thomas?
Felix Thomas.
Of Felix Thomas, okay. And I'm going to let this be entered into evidence because I don't think it contains any hearsay. And counsel, you didn't give me any other reason other than you didn't like what it said, that it was inconsistent with your client's affidavit, okay? But you can make that argument, but that's going to be entered into evidence. All right, continue with your argument.
It says in the affidavit that at the time of the collision, Felix Thomas was proceeding straight forward, and Mr. Williams was in the left lane, where the only cause of the accident was the violations due to Mr. Williams' turn into the right lane, and that Felix Thomas was not cited for any violations.
Okay, you mentioned that Mr. Williams pled guilty?
Yes, he pled guilty at the scene where he stated, quote, "I was trying to make a button-hook turn. I'm sorry I hit you. I didn't see you. I messed up your car."
What is that quote from?
The affidavit.
Of who?
Felix Thomas.
Are you sure? Okay. Where did he get that statement from? He told Mr. Thomas that at the scene?
Yes.
Okay. Counsel, did your client admit to being at fault at the scene?
He said he was sorry that he did hit him. And
Who? So your client admits to saying that?
he said that he was sorry that he did hit him and he did not see him until he was mid-seconds away from going into him. Because while he was turning, he was checking his rearview mirrors every so often. And until he was, right when he was starting to turn, he noticed that he was speeding by him, trying to pass him. And he still hit him, but he was going slow enough that it didn't cause that bad damage.
You know, counsel, that's interesting because you know, we've all seen somebody try to beat the turn. You know, if you know a big truck is about to turn and you think you can just squeeze on by, is that not what happened here? Is that not what really happened here?
No, Your Honor, we believe that if Felix Thomas had enough time to think that he could speed up and miss it, then the truck was turning too soon. That even if he would have continued at his normal pace, there would have been a collision.
But I do have to say that he should, he did not see him whatsoever until he was starting to turn, and then he was mid-seconds away before, because he was trying to get around him because he did not want to.
Counsel, just for my benefit, when you say he's, let's state the
William.
names of the people you're talking about.
William was looking around, and he did not see them. He did not see Thomas until he was mid-seconds away, which it was be too late for him to completely stop because he was halfway into the other lane.
I mean, this is a big truck. You can't stop it on a dime, right?
If Mr. Williams had 21 years of trucking experience and was properly checking his window or his mirrors, he should have noticed the car.
So you're arguing that Mr. Williams is 100% liable.
Yes.
You're arguing your client has no liability whatsoever.
Yes, Your Honor.
No comparative fault at all.
Yes, Your Honor.
Counsel?
Well, Mr. Thomasy, was he not a truck driver for the Marines? And he is an officer right now, so shouldn't he be aware of the laws and how truck drivers should be turning? Since he does also have previous experience.
Counsel, address me, not your co-counsel, not your opponent. Go ahead.
Well, Your Honor, shouldn't Thomasy, since he has previous experience as a truck driver driving for the Marines, have, and also be a deputy for the law, know of the accidents between 18-wheelers and what to do?
That's a good point, counsel. I mean, we're talking about an officer here. What appears to me to be trying to beat a turn, and should know better.
But we would also like to offer, file, and introduce the evidence, the document, court minutes, into evidence stating that Mr. Williams took complete responsibility of the crime, of the crash, where it states his name, that he pled guilty to an improper turn, and that he paid in full the $50 of the disposition, giving full knowledge of he was in the wrong.
Do you have an objection to that offering?
Yes.
It's not appropriate because
And counsel, this is the court minutes, correct?
Yes, Your Honor.
They're offering the court minutes into evidence. Any objection to that offering, counsel?
Articles 66 and 62 do not permit a party to utilize unsworn and unverified documents as summary judgment.
Counsel, let me see the document. This is not notarized, counsel. This is it's from the clerk signed it, but it's not an authentic document is what counsel is arguing. So I'm not gonna allow that to be into the record. And really, counsel, if it's not in the record, we can't consider the fact that he pled guilty. Okay? So what else you got? Would your co-counsel have anything? Counsel?
We have an affidavit for a collision expert that was hired by Danny Williams.
Okay, has your opponent seen it?
No, ma'am.
Let them look at that. Who is this expert?
His name is G.W. McClintock.
And what are his qualifications?
He specializes in collisions and accidents. And he was also called upon by Danny to oversee what happened.
So an accident reconstructionist expert.
Yes, I didn't know what it was.
Has this accident reconstructionist expert ever testified in any other courts of law?
It wasn't listed in the affidavit, but I'm pretty sure. We didn't really ask him.
Okay, counsel, any objection to this affidavit?
No, Your Honor.
Okay. Typically, I would require that we have a hearing to determine whether this expert is qualified, but counsel has not opposed it. So I'm going to admit it into evidence, and I'm going to go ahead and qualify him as an expert. And so tell me your argument regarding his affidavit.
G.W. McClintock was contacted by Danny Williams of the collision between him and Felix Thomas that occurred on March 1st, 2007. I am an expert in dealing in undecided and unknown accidents. My field is worldwide. My findings are as follows. Vehicle 1 William, Vehicle 2 Thomas. Mr. Williams stated that he was going no more than 10 to 15 miles per hour. Mr. Thomas stated that he was already in the right lane. For Vehicle 2 to be hit, he was traveling in the direction of Vehicle 1 at the speed to put him in the area, and he was hit, and he was in his vision and saw the truck was making a turn and speeded up seconds before impact, hoping to beat Mr. Williams' right turn by sneaking by him on the right side.
Okay, so your expert is essentially saying that he was trying to beat the turn. Counsel?
Lastly, I would like to offer, file, and introduce the police report into evidence where two law enforcement worked on the document. One of which was at the scene, Felix Thomas, where it states that Mr. Williams was in the wrong and that there was no violations due to Thomas's actions.
Okay, so do you have any objection to the police report?
We have the objection because the police report is hearsay. Because Officer Clanton was not at the scene of the crime when it happened. So she has really just what Williams and Thomas both said would happen. So she has no real proof of the accident which took place.
Williams would have had to agree to what was put into the police report. Therefore, the police officer would have had to know his pronunciation of guilt at the crime, at the scene.
Okay, I'm not gonna allow the police report in since typically police reports are hearsay, but it's neither here nor there because as you can see, we have two completely different stories here and issues of credibility, meaning you're claiming you got the police officer and you know he knows what he's doing, and you're claiming your client has experience in trucking and all that. It just creates issues of fact. So I'm going to deny the motion for summary judgment. Thank you there.
Okay, guys, I need all of your legal